Yeah, let's get going. This is 6:30. I hope a few more people will join. Good evening, everyone. Welcome to this second webinar about ES property education. And let me introduce the project team to those who couldn't participate last week. We have our graduate student Raksha Khanka, a very active, energetic young lady. She's helping us. And then we have Dr. Bandari, agritourism and value-added agricultural marketing specialist and the co-director of this year's property education project. And our very well-renowned legal specialist, Miss Nicole Cook is with us, so I am very excited when she is in the attendance. I feel very confident, and she has multiple degrees. You can see on the slide, and she has tons of experience. I hope you take advantage of her being here. And then also, oh, sorry, and she the co-director of this year's property project. And then comes today's speaker, Samantha Capeldo, and you can see her multiple degrees as well. And she is the Senior Legal Research Associate with Agricultural Law Education Initiative, also with University of Maryland Eastern Shore Extension, and she's our colleague. We are part of this team. And welcome, Ms. Capeldo. And then I am Leela Karki. I am the Associate Professor of Agricultural Economics and Extension Program Evaluation Specialist here at the University of Maryland Eastern Shore. I am the director of this ES property project. And I would like to share a couple of housekeeping things. Hope you will mark your calendar for the next event. That is going to be June the 19th, the third session of this year's property education webinar series. That will be about resolution, and Ms. Cook will be there. And then we have scheduled one in-person workshop in Crisfield, Maryland. I would like to request all of you, if you have any people in your contact in this area, please let them know so they can take advantage of this in-person session in June the 28th. And then as I mentioned briefly last week also, we are free to organize any events in person also across Maryland, and we have organized like 10 workshops already. And if any one of you would like to have in-person session in your town, in your location, and you will be the host, and we can talk on the team and come and discuss with your team in person. That is also possible. And then what's wrong here? And then I request you to fill out a short evaluation form at the end before you go out from the session. And then I think Ms. Capalda will share her thought, or Ms. Cook, whether they would like to interact going forward or at the end. This is up to you people. And as I said, please mark your calendar on the 19th for the third session. And Crisfield also I mentioned, and recording will be available along with all presentations in a bundle after we finish with the third session on the 19th. And then also, as I mentioned and requested, we can organize in person in your local area also, if possible. And the main purpose of this Yes Property Education workshop at the community level is to provide basic training on Yes Property to communities and any individual who is interested to learn about this Yes Property things. So I request to share the information in your network so many people can take advantage of this. And this has three major sections that we have been dealing with. And the first one is introductory portion that I spoke briefly last week. And today, Ms. Capaldo will be talking about how we prevent yes property, or at least minimize from prevention perspective. And I don't want to take her time. And without any delay, I would like Ms. Capaldo take the floor and share and educate about preventing yes property to all of us. Ms. Capaldo, please.
Thank you, Dr. Harkey. I'm going to share my screen.
And let me stop this one. Yeah.
Okay, can everybody see my slides?
Excellent.
So as Dr. Harkey mentioned, this is the second presentation in the UMAS Extension webinar series on understanding heirs property. And I'm going to skip the purpose, as Dr. Harkey mentioned. And then these are our partner organizations that help develop these training materials. These are the authors who help develop the training materials. And then I am the presenter today. So this webinar is going to cover how to prevent heirs property. Specifically, I'm going to discuss the basics of estate and succession planning and the steps to prevent heirs property when establishing a will. As Dr. Harkey mentioned, next week, Nicole is going to talk about how to resolve heirs property issues. Just some important notes before we begin. These materials are intended to present general information about preventing heirs property. They primarily draw upon information in the Southern United States. The information may not be applicable to every state or territory, and these materials do not provide legal advice. Specific advice should be obtained from an attorney or another professional well-versed in the facts and circumstances related to the individual seeking advice and the jurisdiction where the property is located. Just a few other points. This training is being recorded and it will be posted on the UMES Extension website. So to protect everyone's private information, no personal stories tonight, and any kind of personal questions should be asked outside of the group setting. General questions are welcome. And kind of as we go through, if you have questions, if you could just put them in the chat and we'll talk about those at the end of the presentation. So these are the topics we're going to be discussing today. Contemplating estate planning, important terms, the basics of estate planning or succession planning, working with an attorney, avoiding heirs property when writing your will, and other planning strategies to prevent heirs property. So in the chat function, I think Dr. Harkey mentioned we're going to try to do some interaction tonight. So in the chat, if you could kind of enter what you would like to know about estate planning. Many people think estate planning is only for the wealthy and people who have wealth, but it's not true. Estate planning is for everybody. So we just kind of wanted to get an idea of what you're interested in knowing about this topic. I'm going to keep going while you guys think about that. So along with the interaction, how many of you guys have used an attorney to get an estate plan in place? So use the raise your hand function, or if your camera's on, you can just raise your hand. So I saw one hand go up. I have also. Oh, there's another hand. So yeah, so a few of us have. And we'll kind of talk about how to work with an attorney in this process a little bit later in the presentation. So kind of in this beginning part of the presentation, we're going to talk about some of the statistics, a little bit about kind of why people don't have estate planning in place. So there was some speculation that the COVID-19 pandemic would lead to more Americans getting wills. And as you can see from this chart, that really wasn't the case. And I just looked at the updated numbers. The person or the group that did this study is caring.com. And they did a 2025 study that actually showed that the amount of Americans with a will decreased from 33.1% in 2022 to now that number is 24%. So what everybody speculated was going to happen with the pandemic, it definitely didn't. And so this is a study done by Gallup, and it kind of broke down some of the key demographics and who has a will and who doesn't. If you just want to enter in the chat, if anything surprises you about this, these statistics, or kind of what did you notice? The thing that stuck out the most to me is the very large discrepancy between white adults and non-white adults. Some of the reasons for this is there's historical issues with access to legal service, distrust of the legal system, and some lack of education on the need to have an estate plan among non-white adults. So that's kind of why we see this large discrepancy between white and non-white adults. Another thing that stuck out to me was that kind of the percentages in the age groups. In this 18 to 29 range, only 20% of adults have a will, and then it kind of increases up from there. That didn't really surprise me. It's just something I noticed when I was studying or when I was looking at this. So what are the reasons for not having an estate plan in place? So that caring.com study that I mentioned a few slides ago, they also asked their participants why they haven't engaged in estate planning. And so the number one reason that Americans hadn't engaged in estate planning is because they just didn't get around to it. And that was followed pretty closely by they don't have enough assets to leave everyone. But as we discussed a few slides ago, estate planning is for everybody. So it's just kind of interesting to see what reasons people have outlined as to why they haven't engaged in this process. So what are the costs of not having an estate plan? So like we just talked about, a lot of people worry about the money and the time and the energy to make a will. They have to get a lawyer, they have to figure out what they have and decide who's going to get what and how that's going to make people feel. It also means they have to think about their own mortality. But not having an estate plan can be pretty costly, not only for your family, but also for you. So for your family, heirs will incur higher taxes, estate and inheritance taxes on property passed, for example, without a will. And probate, which is the court process for enforcing or implementing a will, can be very costly and time consuming. And then for you, if you become incapacitated and don't have the necessary documents in place, like a living will or a power of attorney, your wishes might not be known or followed. And this is also costly, again, for your loved ones, because getting guardianship to make decisions on your behalf after you've already become incapacitated can be very expensive. So if you're comfortable entering into the chat, how comfortable are you talking about death? So from 1 to 10, 1 being nope, not comfortable at all, and 10 being very comfortable. So many people aren't comfortable talking about death. I saw one person put that they are very comfortable. Oh, a couple people. So many people aren't comfortable talking about this, and dying or becoming too sick to care for themselves or their families. Lots of people feel like if they write a will and engage in this process, they're increasing the odds that they might die. but there are upsides about talking about death and our mortality. It helps us live more fully. We can make plans for continuing to care for our loved ones even after we are gone. And so we wanted to provide a resource because we know that for many families, but especially for farm families, relationships are the main challenge to having those necessary conversations about planning for the future, treating family members fairly and equally, dealing with off-farm heirs, and addressing in-law relationships are often one of the biggest, most difficult obstacles farm families face when building an estate plan. And so this is a resource. It's the Conversation Project. And it has talking points and worksheets to help families have those hard conversations. And a copy of the slides, I believe, was emailed, and it will be on the website kind of after these 3 sessions. And so you guys will have the links to some of these resources. So we're going to start off the presentation with a little game. We're going to look at some definitions. These are some common terms used in estate planning. Some of you have already heard us use these terms, but before we continue, we just want to get you more familiar. I know Raksha posted the handout in the chat, but I also have kind of the categories that we're going to be talking about on the slide. So the first thing we're going to look at is some of these during life documents. I'm going to give you guys a minute or two to read through these, and then I'm going to ask you the question. Okay, did everybody get a chance to read them? And so the first question is, which of the 3 things listed in this section, so conservatorship and or guardianship, living will, or also known as an advanced healthcare directive, or a power of attorney, are not actually a physical document? If you guys want it, you guys can put your answer in the chat. Just give you a few more seconds. Yep. So Ruth and Jill, you guys are exactly correct. So a conservatorship and Dina. So a conservatorship or guardianship is not an actual physical document. So this is when a court chooses someone to take care of another person who can't manage their own finances, health, or daily needs. So it's not a document, but if you would like to be able to select who would become your conservator in case you become incapacitated, you can plan ahead by creating a legal document, like a durable power of attorney or healthcare directive. A durable power of attorney allows you to choose someone to handle your financial matters if you're unable to, while a healthcare directive names somebody to make medical decisions on your behalf. If you become incapacitated without these documents in place, your family or friends would need to petition the court to appoint a conservator for you. So the next kind of group of words we're going to look at are end of life concepts, roles, and documents. So we're going to talk about here assets, decedents, estates, estate administration, intestate, probate, and then testate. So I'm going to give you guys a few minutes to read these. I know there's a lot, and then I'll ask the second question. Okay, so of these 7 concepts listed, which 2 can apply to somebody who is alive or dead? And then again, go ahead and put your answer in the chat, and I'll give you guys a minute or two. Yep. So Ruth and Dina, exactly right. Assets and estates can both apply to living and deceased people. So of course, living people have assets, things like their house, their car, their savings. And when they die, their assets are then distributed. So how they're distributed is really what we're talking about today, whether their assets are distributed formally and according to the decedent's wishes through a will or a trust, or they're distributed according to the state's intestacy laws because the person didn't have a will or any plan when they died for passing on their assets. Or, as has often been the case, the person dies without a will and there isn't any court action taken, and the deceased person's things just sort of find their way to family members, or folks just carry on with things. And over time, people don't even know that their great great grandparents might have owned some land. Living people also have estates, and so an estate refers to all of the property, assets, and debts you own at any given time. While the term is often used when someone dies to describe what they leave behind, it also applies to the things you own and manage while you're living. Your estate can include things like your home, real estate, bank accounts, investment, and personal belongings. So the last group of terms we're going to talk about here. The handout has a lot more, but these are kind of the 3 big categories we wanted to hit on today. So the last group is ownership and distribution of property. So go ahead and read through these, and then I'll ask the last question. Okay, so under Maryland law, which 2 ways can't property be held or transferred? In other words, there are 2 terms on this list that don't apply in Maryland. Which are they? And again, go ahead and put your answer in the chat. Is it Raksha? Yes, that is one of them. So the 2 that do not apply in Maryland are community property and transfer on death or payable on death deeds. So Maryland does not recognize community property for married couples. Instead, Maryland follows an equitable distribution system. In equitable distribution states, marital property is divided fairly, though not necessarily equally, during a divorce based on factors like each spouse's financial contribution, the length of the marriage, the needs of each party. That's different from community property states where marital assets are typically split 50-50. Maryland also currently doesn't allow for real estate to be transferred with a transfer on death deed, also known as a beneficiary deed. There have been bills proposed in the General Assembly over the last few years that would allow for transfer on death deeds. But as we sit here today, property owners in Maryland cannot use a transfer on death deed to designate a beneficiary who will automatically inherit the property upon the owner's death. So now we're going to get into some of the basics of estate planning. So again, we all need an estate plan. Most people take care of their property while they're living, but many of these same people make no plans for its management after their death, which is really when their guidance is most needed. As a result, the state decides how their belongings will be distributed. And that's why everybody should consider having an estate or succession plan. So again, if you do not decide how you want your estate divided, the state where your estate or property is located will decide for you. And most people don't want the state just determining how their property is divided among their heirs. So let's talk about that process of what happens when there isn't an estate plan in place or a will. So if someone dies without a will, it's called intestate, which means that the state uses established rules to determine the distribution of the property. So when someone dies without a will, the government has an estate plan for them. So essentially, you lose your voice because you lose your opportunity to say how you want your property distributed. It depends on what other family members outlive you. Who your heirs and descendants are at the time of your death determines the starting point for the ultimate distributions. And each state has like a predetermined in their state statutes on how this works. Dying intestate can add significant time to the process of the distribution. And if your children are minors, the court will appoint a representative to look after their interests. Dying intestate may have estate and inheritance tax consequences. So we're doing good on time. So we're gonna watch a little video of about what happens if someone dies without a will in Maryland. Sorry, I forgot I muted myself. So as you can see, that video really just went through kind of the state determined guide of what happens when you die without a estate plan or a will in place. So now let's talk about wills. So there's two types of wills, living wills and last will and testament. So a living will is a written statement that details the medical treatment preferences in the event the person is not able to express his or her wishes. This includes a healthcare power of attorney and an advance health directive in some states. This is no longer in effect after the person has died. On the other hand, a last will and testament is a legal document that designates how property, assets, and dependent responsibilities are distributed after death. This does not take effect until the person has died. So some states, but not all, recognize what's called a holographic will. Maryland does not recognize these, but I'll still just give you kind of the highlights about them. In the states that permit these documents, they are handwritten and signed by the testator, and they're not witnessed. So, but in these states that recognize holographic wills, these wills must still meet the minimum requirements, such as proof that the testator wrote it, testator being the person who is drafting the will, or who it's the will of the person, that they wrote it and had the mental capacity to do so. This type of will can slow the process down and may impact other benefits as well. So wills in Maryland. So a valid will in Maryland must be in writing, signed by the person making the will, and attested and signed by two credible witnesses in the presence of the person making the will. To make a will in Maryland, you must be 18 years old and legally competent. And you must also be 18 years old and legally competent to make a will and to serve as a witness to the will. If you have a will prepared outside of Maryland, it's valid if it was executed in accordance with the laws of the state, jurisdiction, or country in which it was prepared. Handwritten wills are valid in Maryland. Electronic wills are valid only in very limited circumstances. Audio, oral, and video wills are not valid in Maryland. So the benefits of having a last will and testament, you can put specific wishes for your funeral, choose who you want to carry out your wishes, limit inheritance disputes, clarify the gifting of possessions and money. This is subject to state laws pertaining to specific spousal rights. Identify who should care for children or dependents, helps heirs access your assets faster and easier, and may reduce inheritance taxes. So now let's talk about how wills are executed, which is commonly called the probate process. Each state will have a specific process for estate administration. Some states file copies of probated wills in the land records. Other states have the executor or administrator file a deed on behalf of the estate. Each state's process is different, but generally the process includes the executor files in the local court after the testator / decedent's death. But not all wills must be probated. Probate will likely be needed if there's real estate involved, the beneficiaries are minors, there's disputes over asset distribution, assets are complex or high in value, or the will is not written well. So Maryland has a really archaic and sometimes confusing probate system. It has both a register of wills and an orphans court that are both used in the probate process. The difference between them depends on the type of probate that is needed. So the register of wills is for administrative probate. It's most common for regular estates to be opened and closed through administrative probate. Administrative probate is a proceeding that is initiated by an interested person with the register of wills for the appointment of a personal representative and for the probate of a will or the determination of intestacy of the decedent. On the other hand, the orphans court is for judicial probate. So if a case goes through judicial probate, there are questions regarding the validity of all or part of the will or the estate. Judicial probate might also apply if there is more than one qualified person applying to become the personal representative. Through judicial probate, the court system will intervene to decide these disputes. So we're going to watch one more short video about how it gives an explainer of how the probate process works in Maryland. Okay, so that video just went into a little bit about how the probate process works in Maryland. So next we're going to talk about when to update your will. So updating a will after the death of someone named in your will is important to prevent later difficulties. For instance, if a child is deceased and the will conveys property to more than one unnamed grandchild, it creates a risk for difficulties arising from lack of unanimous consent. Updating wills after the death of a spouse or a child may avoid this problem. Similarly, a change in circumstances surrounding people or things named in the will should lead to the will being updated. So one of the other handouts in the list that Raksha sent is this estate planning worksheet. So the purpose of this worksheet is to help you take action once you leave this workshop. Most people who go to other estate planning workshops don't finish the process, but I know you will because this worksheet helps clarify how this whole estate planning process works. So using a checklist like this can streamline the process of setting up your estate plan. Just remember to set realistic and generous deadlines to complete each step. An important first step in creating a strategy is to take some time to think about what you value. Knowing your values and priorities helps determine what matters most in your legacy. For example, if you treasure your antique clock passed down from a parent, you'll want to ensure that your will states who should receive the heirloom, and you might even want to provide instructions on how to care for it. I'm going to share just a little personal story. I know we're not supposed to, but I am comfortable sharing this one. My grandma has a bunch of antique pottery, and so in her included with her will is each piece and who it goes to. So my uncle gets some, my mom gets some, I get some, my cousins get some. She really values this antique pottery, so she wanted to make sure it was outlined who gets what pieces. So we're going to switch gears and we're going to talk about some important considerations in working with a lawyer during the process. So the benefits to working with an attorney. It's not required, but an attorney can prevent the problem of incorrect wording or an invalid will. Incorrect wording can lead to the will being contested, which adds to the length of time and potentially family turmoil. So the cost of having a will drawn up by an attorney varies widely. This slide gives you kind of some general information. A simple will is generally going to be around $500 to $600 per person. Nationwide, the average cost for an attorney or firm to create a will is between $900 and $1,500. Most firms will reduce their price to a few $100s when adding on a second nearly identical will for a spouse. It's also very common for a lawyer to charge a flat fee to write a will and other kind of basic estate planning documents, and this flat fee can range from $300 to $1,000. If specific tax planning is also needed, the will and tax advice will be more expensive. Some other factors that can influence the cost include just some general state variations and kind of attorney to attorney variations. Again, some charging the flat fee versus a per hour charge. And then the more complicated your situation is, the more expensive the will be. So lawyers can have a variety of specialties, and this is important to understand. So you're choosing one with the best training experience, training and experience. Not all lawyers know all parts of the law. One part is trusted estates. So some states do recognize specialization and certification of lawyers. For example, the Florida Bar recognizes a specialty for wills, trusts, and estates. And also some lawyers have advanced degrees, such as an LLM in taxation, which an LLM is a master's of law. So it's a degree after the law degree. This is some examples of specialty areas of the law. So as you can see, trusted estates, depending on the state, can be a specialty area. So choosing an attorney is similar to kind of other good shopping. This slide gives you some kind of key points to guide the decision. Definitely comparison shop, ask for referrals from friends and family, look for lawyers who have experience in estate and succession planning, and be sure that they're licensed in the state that your property is in and that you're drafting a will in. So what questions to ask when you meet with the lawyer? So you want to listen and give the best information so that the attorney can assess your needs in the best way possible. So you want to ask, what percentage of your practice involves estate planning? Do you have any conflicts of interest that I should know about before I hire you? What documents will be prepared? How long will it take? How will you keep me informed of progress? And what is the ballpark figure of my total bill and what would cause the bill to change? Being prepared is likely going to save you time and money when you're working with an attorney. An attorney may have you fill out a form, give you a list of what documents to bring with you on that first appointment. These documents could include a written summary of what you want to achieve, documents with full names and addresses for you, your spouse, children, and anyone else you plan to include in your will, complete income tax returns from the previous 3 to 5 years, a balance sheet, so your assets and liabilities, deeds and mortgages, a detailed list of any oral or written agreements, marital agreements and or divorce decrees, beneficiary designations, so for insurance, retirement plans, things like that. Any prior wills that you've executed, power of attorneys, or any other pre-existing versions. We talked about kind of that family meeting process. Family meeting may be needed to gather some of these documents if you don't have all of them. So ensure that your will is safe by following these 3 steps. So you're going to want to store your original will in a safe place. Let the executor of the will or the executor of the estate know where the original will is stored, along with any kind of needed information, such as the password for a safe, if it's in a safe, or any other kind of like locked area. Give duplicate signed copies to the executor and your attorney if you work with an attorney to draft the will. So another interactive time. So true or false, making a will prevents heirs property. Yep, so it is false. Having a will does not necessarily mean you avoid creating heirs property. Now we're going to talk about how to avoid heirs property in a will. So simple will and how this can create similar issues to heirs property. So a simple will often leave all assets, including real property, first to a spouse, second if the spouse is deceased, equally to the children. So if children inherit under this simple type of will, they hold an undivided interest in the property. So unlike heirs property, the property is titled in their name. But like heirs property, they can't use it without unanimous consent of all siblings involved. So how to avoid heirs property in a will. So put in writing how the land would be divided among spouse and children if they inherit. And some common ways to divide the property is physically divided into separate parcels for each person using valid legal descriptions. Physical division of the property may require having a survey done. Properties of the same acreage may have different market or monetary values. For example, some properties having higher value are those having greater road frontage, more fertile soils, having utilities present, etc. So some people might choose to have the property divided after death based on equal value of the parcels, perhaps divided by an appraiser or another person. Sometimes if the appraiser or other person is asked to divide property after the death of the property owner, they might first divide the overall property into pieces of equal value, not necessarily equal size. And then there may be a drawing where each child obtains a parcel at random. Other problems created if children are under the age of majority when they inherit the property. So you want to ask your lawyer to advise you on some of these issues. So how to provide for the payment of debts and taxes, so the property division is not affected by claims of creditors or required tax payments, and what is needed in terms of a temporary process on how to manage the property, whether it's farm, ranch, forest, to avoid interruption in the business. So other planning strategies for how to prevent heirs property. Transferring title by deed. So Maryland does not allow property to be transferred through a transfer on death deed, but we still kind of wanted to give the highlights of how this works. So in this case, the real property would be conveyed by a deed rather than by a will. Sorry, I'm going to back up a little bit. So you can convey the real property before death, which is allowed in Maryland. It's the transfer on death deed that's not allowed in Maryland. So I just want to make sure I'm clear about that using a deed before death to transfer property is allowed. So in that case, a recorded deed would take precedence over a will disposing the same property, and any deed should be prepared by a licensed attorney. Kind of other options, like I just mentioned, conveying the property before death, reserving or granting a life estate when conveying property to allow limited use by the life tenant prior to death, and then conveying title by transfer on death deed, which again is not allowed in Maryland. So a life estate, it can be limited so as to require the holder of the life estate to live on the property for a specified number of months each year. If there is a, oh, hold on, sorry. I have lots of screens. So with a life estate, one spouse can prefer to leave the real property as a life estate to a spouse or a child in the event of circumstances important to that parent. So it can be used to plan for property management if a spouse needs to go to a nursing home, ensuring the child receives the property after the death of a spouse, providing for the care of someone with special needs, or allowing someone earning their livelihood from the property to remain there. But a life estate can be limited. So it require the holder to live on the property for a specified number of months each year. If there's a concern that commitment to a nursing home or other facility would not enable the holder to manage the property. So the property, it could be managed by others in order to keep the income stream benefiting the resident of the nursing home going towards that person. This may have implication on eligibility for government benefits, though. And then your lawyer should advise you as to what rights and obligations pass under a life estate under the law of the state where your property is located, so that you can make changes to match your desires. In most states, a life tenant has exclusive control of the property during their life, and they generally must keep the property in good repair. So another option is to place property in an entity. So the property can be conveyed to a trust, a corporation, a limited liability company, or another entity. This can be done prior to your death, but there could be property tax implications if this is a homestead. And then it can also be transferred into an entity upon death if designated in your will. And again, for entities, you're definitely going to want to get lawyers' assistance on this. So a little bit more details on this. Using a trust or business entity can avoid partition, and the decedent can determine the use and management of the property after his or her death. So generally, interests in entities can include shares of stocks if it's a corporation, membership interests if it's a limited liability company, or partnership shares or units in a partnership. So for trusts, some trusts are created by a will, other trusts are created prior to the owner's death by a trust instrument. If the trust is created prior to the owner's death, the owner will deed their property into the trust. Trusts are managed by one or more trustees who have broad discretionary powers. And then prior to the death of either spouse, your lawyer can help you convey property to a trust or corporation, limited liability company, or other entity. If the property is placed into an entity prior to your death, A will can be used to provide for the interest in the entity to be left to a spouse or children. So you can do it through a will or, again, prior to your death. So upon death, if you have kept the property in your name, a will may place property in a trust for the benefit of a spouse or children. This is called a pour-over trust. All of the entities except for a general partnership require some sort of administrative work. So this is where that lawyer's assistant really comes in, because some examples of that administrative work includes completing paperwork to create the entity, retitling property in the name of the entity, drafting operating agreements, articles of incorporation, and there are some, depending on the entity, some annual reporting and record keeping requirements. So again, if you want to go the entity route, definitely consult a lawyer to make sure that any applicable laws are followed for both creating and maintaining the entity. That way they provide the succession plan benefits. So some advantages and disadvantages of placing property in an entity. Some advantages include the property stays together in one undivided tract and it's managed by a trustee if it's held in the trust, or it's managed by the board, managers, or general partners if it's held in some other sort of business entity. They don't require unanimous consent for most management decisions. And there may be a prohibition on sale of the property or interests. And then some disadvantages include restrictions placed on the transfer of interests in the entity. They can make a sale difficult when a child needs to sell for health, financial, or other personal reasons. And there could be disagreements over management decisions made by others that can cause some family turmoil. For entities other than a trust, unanimous consent of the owners of an interest in the entity may be required for like the big decisions like selling a property, placing a mortgage on it. General day-to-day affairs are decided by kind of a majority vote of the board of directors for a corporation, or the managers for a limited liability company, and then partners for a partnership. A holdout by any one of the deciders usually not create a deadlock. Some of these decisions can be amended through the operating agreement or articles of incorporation, but these are just kind of the general guidelines. And then a common requirement may include restrictions on the transfer of interests in family-owned entities. So a proposed sale may first be required to be offered to the other owners of the entity before being sold outside to a third party. So the last approach is maintaining the property as heirs property, if this is what the family desires, through current marketable title. So after the title is examined, the names and percentage interests of each family member should be determined. Title should be updated to reflect the current ownership and percentage interests according to the laws of the state where the property is located. And this may include affidavits of heirship, probate of wills, administration of estates, or a judicial determination of heirship. So some advantages and disadvantages to maintaining the property as heirs property. The advantages include this keeps the family current as to the names and percentages of ownership of family members, and then this can keep the relationships between the family members. Some disadvantages include that they must be updated upon the death of each heir to keep those names and percentages current. It doesn't address any kind of incompetence during a lifetime. This doesn't prevent an heir from selling their fractional interest, and it doesn't prevent an heir or purchaser from seeking a partition of the property. And Nicole was going to talk a little bit more of the partition aspect next week.